As Judge Jacob Witt summarized it, the primary focus of the case against Japheth Bennett is whether he did indeed kill Ellis Gacho Meighan in September of 2009, and if he did, should he spend the rest of his natural life behind bars for it. In the original trial, a key witness repudiated his original statement to police on the witness stand, saying that he did not in fact see Bennett at the scene that night. But the jury disregarded the courtroom testimony, and according to Anthony Sylvester, convicted based on evidence that should not have been admitted.
Now, as it relates to the admission of that witness statement, verse 1 to section 73A of the Evidence Act, our submission is that, and this is where both prongs 1 and 2 relate, our respectful submission is that that statement ought to have been excluded. And allied to that submission is that the statement is allied to that submission is that when that statement if that statement were properly excluded, what would have obtained is that there would not have been any evidence to ground the conviction, and so that in the circumstances a submission of no case to answer would or ought to have been upheld.
As for sentencing, Sylvester argued that Belize had little provision for sentencing juveniles involved in murder. In the absence of the death penalty, the sentence is customarily life imprisonment. But a sentence of detention at the court's pleasure still does significant harm to plans for rehabilitation.
Recently, in the August case, August would have been an adult at the time of the commission of the offense. I agree that just a year over the age, but he would have been 19. And the term of sentence imposed was 30 years. It was a fixed term. Consequent to the enactment of the Parole Act, the determinate sentence is a very important aspect of a convict's sentence because, as your honors are aware, it is only when there is a determinate or fixed sentence that a convict would be able to have certainty as to when he would be parolable. So that, for instance, in August's case, he would know for certain when he would be eligible for parole. This applicant would not be in such a situation. He would face the position where he would first be sentenced to a fixed term, and then thereafter be subject, that sentence would be subject to review.
Director of Public Prosecutions Sherilyn Vidal argued for the safety of Bennett's conviction. As to sentencing, a new regime in law does allow juveniles to have second chances.
When a juvenile has been convicted and a judge is sitting to pass a sentence, the sentence may be very, very different in nature at that time than if a judge is saying, you're going to be sentenced to detention at the court's pleasure. You will come back here in 2 years and I will monitor your progress. And then in another 2 years, I will monitor your progress. It may very well be that at the end of that 4-year period, because this juvenile has continued going to school, has not gotten into any trouble at all at the prison, is showing movement towards rehabilitation, that the court may be minded in a very short period of time to release that juvenile, as opposed to a judge who's sitting with the facts. Of course, yes, the mitigating factors, the age, maybe a very good record on the part of the juvenile, but the fact of the commission of that offense, it is a different situation if there is this periodic review to see how the character of the juvenile is developing and how his conduct is during that time. And this is the advantage, and this was the purpose of this regime in relation to detention.
Yes, I understand that. It's, of course, a little late now. He's almost 9 years already in prison.
Whether he serves anymore is for this court to decide. Aaron Humes reporting for News 5.